Remain silent. Don't consent to searches.
What the is going on today?
I don't know.
Every crazy loon in the building is coming.
Did you ever tell her that she was going to go to jail for 90 days?
I don't recall that, no. Okay, but you realize you're going to go to Cook County Jail for 90 days.
Well, did you or did you not? Or do you not know?
There was pictures of buildings, secure entrances. There was pictures of police stations. So those were all suspicious.
Does the term suspicious activity have any relation at all to the Fourth Amendment?
I don't know.
Okay. If you see a non-officer put somebody in handcuffs and he says out loud that he's putting the person in handcuffs because she's a woman, would you arrest that person for unlawful imprisonment or for some other crime? Assault, perhaps? If you could go back in time to the day that you arrested her, would you still arrest her?
The man that you're seeing is Lieutenant Donald Milazzo. As a lieutenant with the Cook County Sheriff's Office, you would assume that he knows the law better than anybody. With the way things went for him, however, you'll soon find that such a belief is very much incorrect.
Do you recognize the young lady seated to my right?
Yes.
And who is she?
Amanda Burquist.
And when did you come to know her?
March of last year.
And how did you come to know her?
We observed her outside. We stopped her and detained her.
Why'd you detain her?
For suspicious activity.
What crime did you suspect her of committing?
We suspected her of violating the judicial order, videotaping in and around the building.
And did you say and around the building?
Yes.
Does the judicial order actually say the words and around, or is that your own words?
That was what we were told at the time.
You can see here that the interviewer asks Milazzo if he recognized a woman off screen, who we come to learn is one Miss Amanda Bergquist. If you're unfamiliar with what Milazzo is being sued for, it makes sense not to know her name. But if you've done any research into case law recently, you've likely seen it floating around here or there. In March of 2018, Miss Bergquist went to the Bridgeview Courthouse in order to address 3 traffic tickets that she had been given. At the security checkpoint, she was informed that she was not allowed to film inside the building as she was carrying a large video camera. She elected to leave the building and began filming the outside of it, scanning up and down with her camera. When several officers, including Milazzo, noticed what she was doing, they attempted to ascertain her intentions for filming. Miss Bergquist refused to identify either herself or the reason that she was filming, and remained uncooperative with the officers for the duration of her time there. After a few more moments, the officer detained her in the courthouse, searched through her purse, wallet, pockets, camera, and other personal belongings, and then brought her before the presiding judge, who ordered her to stop recording. As a result, she's suing Milazzo for injuries under the First and Fourth Amendments, claiming it was her right to film outside of the building. That is what Mr. Milazzo is being questioned about.
What could you do to help us to help yourself remember? I'd like an answer. Are there any emails you could look through?
Not that I can recall.
Text messages?
No.
Facebook messages?
It was just the standard policy dating back to after 9/11.
The interviewer is really grilling Milazzo hard in this instance, trying to get him to remember who informed him of this policy. This is important because it was not a policy. Filming outside of a courthouse is entirely legal. It is only filming inside that is against the law. The interviewer is trying to get the point across that nobody told him about this, and that Milazzo was just brandishing his power when he detained Miss Bergquist because she was annoying him. This is expressly not what an officer should do in such a situation.
How many other people that you can think of have been detained for taking pictures outside of the courthouse since 2001?
I couldn't answer that.
Any that you can think of?
There have been other reports done, yes.
Okay. When's the most recent one that you can think of?
I don't know.
The vagueness that Milazzo answers this question with is not surprising. It's very likely that there have not been any examples of people being detained for taking pictures, because it's not within policy to do so. He is simply reaching in order to make himself look better, because he doesn't want it to seem like he specifically broke policy in order to detain Miss Bergquist directly.
And your testimony is that you were told there was a written policy. How is it that this policy was conveyed to you that you're supposed to detain people outside of the building taking pictures?
It was just a standing policy we had.
Did you hear my question?
Can you repeat it?
Sure. How is it that you became aware of the policy? Did somebody tell you? Did somebody post it? Was it an email?
This may seem repetitive to you or I, but there is actually a very specific and strategic thing that the interviewer is doing here, often referred to as weaving the net. He's laying out so many different questions that are slightly related to each other, whose answers might reveal information about another answer. The thing is, if any of those answers given by Milazzo are lies, they can be used in order to show that the other things he said are lies. There are genuine and legitimate reasons as to why recording inside of a courthouse is prohibited. First and foremost, courthouses are spaces where sensitive legal matters, including criminal trials, family disputes, and civil cases, are resolved. Allowing recording devices could compromise the privacy and dignity of individuals involved in these cases. Victims, witnesses, and defendants may be reluctant to testify or share their stories if they fear being recorded, potentially hindering the pursuit of justice. Additionally, the safety of witnesses is a paramount concern. Allowing recording in a courthouse could expose witnesses to potential harm, particularly in criminal cases involving organized crime or violent offenders. Witnesses may be less inclined to come forward with crucial information if their identities or testimonies are recorded and made public. Moreover, permitting recording devices in courtrooms could jeopardize the impartiality and fairness of trials. Jurors may feel pressured or influenced if they know they are being recorded, potentially affecting their decision-making. It's crucial that jurors base their decisions solely on the evidence presented in court, rather than concerns about how they might appear on camera. This all goes to say that there is no reason that recording outside of a courtroom would be prohibited. And it's very likely that such a policy that Milazzo describes has never existed in the first place. The interviewer is trying to catch him in such a lie.
Was there anything in writing about this?
I don't recall.
All right. Have you discussed this case with anybody else in preparation for today other than your lawyer?
No.
All right. Have you reviewed anything?
Just my offense incident reports.
You didn't review the actual policy or the judicial order that you referred to?
No.
Okay. Have you looked at the judicial order since March?
Yes.
All right. When did you look at it? From the time, well, okay. You arrested Ms. Bergquist on, I think it was March 28th, 2018, right?
Correct.
Okay. After you arrested her, did you look at the order that day?
No.
The interviewer is trying to ascertain whether or not Milazzo is well prepared to talk about the actual order he is referring to. It could be the case, of course, that there is no order. But despite everything that he has done, it's very unlikely that Milazzo would directly lie on the stand. It's likely that he does believe that there is such an order, or at least has convinced himself of it. And him going over it well at all would put into question what he actually believes he has the power to do.
You've had a chance to review the order since the arrest?
I read it back then, yes.
Okay. And does it say in and around the building?
It does not.
Right. It says in the building, right?
Yes.
Right. Because in the building is where the order pertains to, right?
Correct.
Outside of the building is public, and anybody could take pictures there all day and all night, right?
Correct.
In fact, Ms. Bergquist could go outside right now and do exactly what she was doing back on the day that you arrested her, and if you saw her doing it, what would you do today?
I want to object. It calls for speculation. You can answer it if you understood the question.
We probably would not have detained her.
The interviewer finally brings up the meat of the argument, and that the order he read does not actually state anything being outside or around the building. Milazzo even admits here that if he were to see Miss Bergquist outside doing exactly what she was doing that day, he would likely not detain her. This is a fairly large revelation. He's admitting that what he did was probably incorrect, which many officers are too headstrong to do.
Would not have detained her. So if you would have actually known the law, you would not have detained her, right?
Well, right now we would know what she was doing out there. But at the time, we didn't know if she was videotaping people coming out, videotaping witnesses, videotaping people that were involved in domestic violence, videotaping inside the door where the posts were. We didn't know that.
And there he goes, effectively destroying any possible credit he built up in the last clip. He could have admitted that he made his mistake, said that he would do better going forward, and maybe he would have even been able to keep his job. Police officers have been allowed to stay on the force after much worse cases. Instead, he's doubling down on saying that what he did that day was correct because they didn't know what she was doing, when that doesn't even matter. What matters is that he incorrectly detained her, which should be owned up to.
Is there any situation in which the person just says, I'm not talking to you, and you would detain them now that you know the actual order?
I'm going to object again. It's calling for speculation. You can answer it if you understood.
I can't say.
All right, well, let me ask you this. Are you armed right now?
Yes.
Are you going to pull out your gun and shoot me right now?
I'm going to object. That's
or no?
argumentative. That's
I'm not
harassment.
arguing with anything.
Let's not do that.
Are you telling him to not answer that question?
No, you can answer, but
I'd like an answer,
let's not
please.
do that.
What was the question again?
Right now, are you going to pull out your gun and shoot somebody? Yes or no?
I'm going to object to form, foundation. Well, what's the question? You're going to pull out your gun and shoot someone?
He answered it. And the reason you wouldn't do it is because it's illegal, right?
Correct.
This is a very interesting moment in the deposition, and it goes to show that in cases like this, even the interviewer can be caught up in emotions. I would say objectively that this question and the emotion behind the man's voice are unprofessional. And if I were Milazzo's lawyer, I would instruct him not to answer this question. But depositions and legal processes in general are never going to be perfect, because laws and processes like these are so innately tied up with humanity, which is by definition imperfect.
Let me ask it this way.
Okay.
Are you allowed to detain people for taking pictures outside of the building, yes or no?
If it falls under suspicious activity, then we can detain people and find out what they're doing and who they are.
And is that a policy, a Cook County Services Department policy?
Suspicious activity, yes.
Yeah, policy 172, right?
Correct.
Suspicious activity reporting. Right, is that the policy?
Correct.
There has been a lot of talk so far about suspicious activity. It's the thing that Milazzo keeps coming back to, claiming that he is allowed to detain people if they are acting suspiciously outside of the courthouse. The interviewer finally reveals that he knows the policy on suspicious activity, and actually has it with him, and very likely intends to grill the man on exactly what it means. This is where depositions can be a bit fun for lawyers. They get that little gotcha moment that TV shows often portray as being in the courtroom. In actual courtrooms, the dramatic moments often seen on TV are a rarity. This is primarily because of the well-structured legal process known as discovery. Before a trial begins, both the prosecution and defense, or the parties in a civil case, are required to exchange all relevant information and evidence. This means that by the time the trial commences, both sides already possess a comprehensive understanding of the case's key facts, documents, witnesses, and evidence. There are few surprises because the information has been disclosed up front. Legal professionals are bound by stringent ethical rules that compel them to be honest and forthcoming with the court and opposing counsel. They are prohibited from concealing or withholding evidence that could benefit the other side, with severe consequences for failing to do so. Attorneys invest substantial time and effort in preparing for trials, leaving little room for unexpected revelations. They meticulously investigate the case, interview witnesses, gather evidence, and craft their arguments. This thorough groundwork significantly reduces the chances of being caught off guard during the trial. The deposition of Milazzo we're currently watching is part of that process.
Is that the policy that you're talking about?
Yes.
Okay, please, I'm going to hand you my highlighter. I'm going to ask you please to highlight the portion there where it tells you that you're allowed to detain people for taking pictures outside of the building.
This is an interesting demonstrative act that isn't seen a lot in depositions like this. Generally, it is simply asking questions, not asking the subject to do certain things like highlighting sections on a page. In this instance, however, it would progress the interviewer's point that there isn't a section that allows Milazzo to arrest people for taking pictures outside of the courthouse. The man proceeds to read through the document and highlight for around a minute and a half. Clearly, he didn't want to miss anything.
I see that there's something on the first page that you highlighted, two things on the second page that you highlighted, and well, the third page is mainly blank, so nothing highlighted there. All right, now, the first thing that you highlighted is, and I'm going to read exactly what you highlighted, examples of suspicious activity may include but are not limited to. Did I read that correctly?
Correct.
Okay. Where does it say there that you get to detain people? And I'm going to hand it back to you so you can show me. And this time highlight, please, where it says you get to detain people.
Okay.
I don't think I'm remiss for saying that this is a rough one for Milazzo, because the interviewer was able to disprove his point from the very first highlighted section. It really was a poor choice of where to mark too, because it genuinely says nothing about him being allowed to detain people for any reason. At least if he'd highlight some of the examples of what could be considered suspicious behavior, he could have insinuated that Bergquist was doing one of them. As it stands, however, he just highlighted a useless formatting sentence.
So now we're moving to the second page. You highlighted two things. One thing over here says that the responsibilities of the respective department head include but are not limited to. Then the next thing is 172.4, reporting and investigation. You highlighted these words. Any member receiving information regarding suspicious activity should take any necessary, immediate, and appropriate action. And that's the end of the highlighting. And your testimony, obviously, is that this authorizes you to detain people who are acting in a way that you feel is suspicious, right?
Yes.
Just so that I understand this correctly, if right now we could go back in time and replay exactly what happened on the day that you arrested Ms. Bergquist. So now we're back to that moment where you don't know her and you don't know what she's doing. But you do get to go back and decide if you're going to arrest her. Are you going to arrest her or not?
I'm going to object again. Is it calls for speculation? You can answer.
You're asking me if it happened tomorrow, what would I do?
Nope, that's not what I asked you.
Okay.
If you could go back in time to the day that you arrested her, would you still arrest her?
So you're asking me if I can go back in time?
Yeah.
I don't know how I could do that.
And now we arrive at a point where many officers get to, whenever it seems to be that they're losing the argument. The absolute pedantry that it requires to pull that bit out of the sentence rather than what he knows the actual substance is. It's just humiliating. Sure, he's following the law, and he's allowed to ask for clarification or not understand things. But to pretend to act out this farce that he thinks the interviewer is asking about time travel just because he brings up a hypothetical question? Well, it's clear that he knows that he's beat.
Are you familiar with the Fourth Amendment, by the way?
Vaguely.
What does it say in your own vague terms?
No illegal search and seizure.
All right, unless there's
Probable cause.
or...
Okay. That's about all I know.
Okay, all right, good enough. You said that's about all I know. All right, now, there was somebody else who asked you the same question that I just asked you about your familiarity with the Fourth Amendment, who's in this room right now. Do you know who that person was? My client, Ms. Bergquist, asked you that, didn't she?
I don't recall.
She asked you, are you familiar with the Fourth Amendment? You don't remember that?
No.
Are you familiar with the Fourth Amendment?
Oh, great. Why do we always get the crazies?
I don't know.
Okay. Did you watch any videos to prepare for today's deposition?
No.
Since the lawsuit was filed, have you watched any videos?
Yes.
Which videos have you seen?
The video that was posted online and Sergeant Larson's body cam.
Excellent. And on that video, you don't remember you asking Ms. Bergquist, I'm sorry, you don't remember Ms. Bergquist asking you if you're familiar with the Fourth Amendment?
I don't recall.
It's a bit sad to hear an officer of the law saying that he's only vaguely familiar with the Fourth Amendment. It's one of the most important ones to the American people. And to hear him discuss it so flippantly really points out the fact that he shouldn't be trusted to uphold it if he can't even learn it. Evidently, Miss Bergquist asked him while being detained if he was familiar with the amendment, and if he had been, perhaps he would have understood that what he was doing was against the law.
If I tell you that your answer was, "Oh great, why do we always get the crazies?" would you dispute that?
No.
Does that sound like something you would say to somebody?
That's something I did say that day, yes.
So you remember saying that?
Yes.
Okay. Do you remember saying that in response to the question, are you familiar with the Fourth Amendment?
No, I just remember saying it.
Why is it that you felt she was one of the crazies?
When people act in a way that is not in their best interest.
How was she acting that was not in her best interest?
Well, at any time, all she had to do is identify herself. We could have done our report and everything could have gone the own.
And if somebody were to threaten you that unless you comply with their demands, they're going to put you in handcuffs, would you automatically necessarily comply with their demands?
Yes.
No object.
You would.
Calls for speculation.
He was able to answer. So you would. So even if there's somebody who is acting as a law enforcement officer, giving you an unlawful order, threatening you with detainment or arrest or 90 days jail, if you don't comply with their unlawful demands, you would still comply?
Yes.
It's hard to take what Milazzo says here seriously. He claims that even if he was being unlawfully questioned and threatened, he would still respond kindly and politely to anybody asking him to identify himself in what he was doing. It cannot be proved that this is a lie, and therefore it's not really prudent to speculate on it, but in my eyes, it's fairly clear that he's lying during this part in order to try to make himself look better.
If you see a non-officer put somebody in handcuffs and he says out loud that he's putting the person in handcuffs because she's a woman, would you arrest that person for unlawful imprisonment or for some other crime? Assault, perhaps?
It's possible.
Okay. Tell me why you would not. You said it's possible. I'm assuming that means you might not. Tell me why you would not arrest that person.
It would depend on the facts behind it.
Gotcha, okay. All right, now let's say that person is an officer. So the person is an officer and says, this person is taking pictures and I subjectively feel it's suspicious because the person taking pictures is a woman, therefore I am going to put her in handcuffs. Would you arrest that officer for putting her in handcuffs?
No.
Why not? Not even a maybe? Just a no?
No.
In any circumstance, would you arrest an officer for unlawfully putting handcuffs on somebody?
No.
A massive amount of bias comes out here in this statement. A direct contradiction just because one example includes an officer and the other doesn't. It's very, very important for officers of the law to hold each other accountable. It's one of the core things that would make a law enforcement agency work. Unfortunately, it so often seems to be the case that officers make excuses for each other and allow others to get away with anything they want, either because they're friends, acquaintances, or simply want to be able to get away themselves with the thing that the other officer is doing. It's one of the worst aspects of the system currently, and why plenty of people believe that it is broken.
You told Judge Felice about the suspiciousness of the pictures and on the video camera, right?
Yes.
Why did you tell him that?
Because there was pictures of railroad yards, secure areas. There was pictures of buildings, secure entrances. There was pictures of police stations. So those were all suspicious.
Buildings, railroad yards, secure entrances, and police stations are suspicious.
Exactly.
When what?
In all the training that we received after 9/11, those were the things we were told to look out for.
Gotcha. And that creates reasonable suspicion of a crime?
Suspicious activity, yes.
Did you hear my question? You like to say the word suspicious activity. I'm focusing on words that are actually included in the law, in our Constitution.
Okay.
So let's talk about this term reasonable suspicion. Have you ever heard that term before?
Yes.
Do you know if that term has any relation to the Fourth Amendment?
Yes.
Does the term suspicious activity have any relation at all to the Fourth Amendment?
I don't know.
Okay, then let's talk about reasonable suspicion for a minute, okay? Did you have any reasonable suspicion that Ms. Bergquist was engaging in any sort of criminal offense?
No.
The officer brings up several pictures that Miss Bergquist had on her camera, which, by law, he should not have access to. They are already fruit of the poison tree simply because he had no reason to arrest her, and him bringing them up to the judge seems to display a possible level of corruption utilized to have the judge order her to stop recording. This, of course, is simply speculation without more evidence on the judge, but it does beg the question.
After this lawsuit was filed, have there been any internal discussions, other than with legal counsel, about that policy?
Just the policy they put out in June?
Exhibit 2,
Yes.
the informational bulletin. Oh, I'm sorry, no, you're talking
Policy.
about policy 172, the one that you believe allows you to detain people based
Correct.
on the subjective belief that they're acting suspiciously, right?
Correct.
Did you ever tell her that she was going to go to jail for 90 days?
I believe we informed her the judge could hold her in contempt for up to 90 days.
But you never told her, matter-of-factly, that she's going to go to jail for 90 days if she doesn't give you her ID?
I don't recall that, no.
Well, did you or did you not? Or do you not know?
I do not recall that.
Is that something that you would do and say?
No.
Okay. So is it fair to sit here today and tell us that you did not tell her that?
I say I didn't recall.
The interviewer asks a few more questions about the policy in particular, and then proceeds to ask Milazzo if he told Miss Bergquist that she was going to be detained for 90 days. This is one of the things that she claims in her lawsuit, and Milazzo proceeds to say that he doesn't recall telling her about it. Seeing how, thus far, he has been less than truthful, it's safe to say that he very likely said something akin to it, if not the exact words themselves.
All she had to do was show you ID and be on her way, right?
It was a short time frame. I don't recall.
Yeah. So, when you told her just show us ID and you'll be on your way, were you lying to her?
No.
Okay, so every time that you told her just show her your ID and you'll be on your way, you were being truthful, right?
Yes.
Okay. And obviously, every time you said that to her, it was before you were instructed to bring her to the judge, right?
I don't recall.
Well, would you have said that after being instructed to bring her to the judge? Would you have given her the option to just show you ID and be on her way after being instructed to bring her to the judge?
No.
Okay. So is it fair to say that your testimony today is that every time you offered that option to her was before you were instructed to bring her to the judge?
True.
Well, I mean, isn't that your story?
As far as I recall, yes.
Okay. So I'm just trying to make sure I understand this. You give her the option, show us your ID, and you can be on your merry way. Obviously, when you gave her that option, it was before you were instructed to bring her to the judge. Isn't that what we just established?
Yes.
Okay. So when you looked through her purse and saw her ID, your testimony before, and correct me if I'm wrong, was now it's too late because you already have to bring her to the judge because you were instructed to do so, right?
Yes.
Okay. So just so that we're crystal clear about this, you gave her the option, show us your ID, you'll be on your merry way. She said no. You get the call, bring her up, and at some point after that is when you saw her ID, right?
Correct.
This is effectively the interviewer setting out the story so that everything would be straight for the record. It gives a fairly clear picture of what happened regarding her ID and why he brought her to the judge in the end of it all. In the end, the Cook County Sheriff's Office was ordered to pay Miss Bergquist $100,000 in damages, with $15,000 of that going to her attorneys. It is currently unclear whether or not Donald Milazzo still works for the office, but given the amount of money and time he cost them, it wouldn't be surprising at all if he was let go at the end of this.